brings us to the seventh session for today on changes proposed in assessment provisions by Aseem Chawla, founder, ASC Legal, Solicitors and Advocate. Aseem is highly qualified professional with a Bar Council membership, a fellow chartered accountant, and certificates from Harvard Kennedy School and Vienna University of Economics and Business. He has over 20 years of experience in legal, business, and tax advice, including international tax, litigation, investment structuring, corporate advisory, and regulatory compliance. Aseem is published author and regularly contributes to academic and professional journals and conferences. It's great to have you here with us, sir.
Well, thank you, Ridhima, for this very benign introduction. I don't know whether I deserve all this, considering the
Definitely do.
The diligence which is exhibited by Mr. Naveen, the erudite team of Taxmann, and all the prolific speakers, including yourselves. I must start with a caveat. I am a senior standing counsel now with the revenue, so please. My request is to take these views as views which are my own personal views, and they need not represent the views of the revenue, so to speak. But anyways, I'm most grateful to all of you for this wonderful opportunity, and thank you. Sharing this budget marathon with all the luminaries is indeed a pleasure. Coming to the topic at hand, I think the team has done a presentation, and Ridhima, if you could ask your technical team to upload it, and I'll quickly take through the contents of the suggested changes in chapter 14, which deals with assessment, as that is my brief for the day. And if there are any questions which do flow from there, I'll try my best to take it within my allocated time of about 30 minutes or so, but thank you once again. Yeah, so please upload the presentation.
Yes, sure, sir. Anshika, could you please upload the presentation and share it? So, sir, you want us to operate it as
Yeah, absolutely.
Perfect. Sorry, it is taking an unexpected time. Meanwhile, you can start.
Okay, pretty much the changes proposed by Finance Bill 2023 dealing with Chapter 14, comprising the assessment-related provisions, are changes with regard to the amendments on the updated return computation of 234B interest, which we all understand. The concept was introduced a couple of years ago when Section 139 capital A was introduced, laying down the provision of updated returns, which could be filed for 2 years from the end of the relevant assessment years. Now, Finance Bill 2023 proposes to amend provisions dealing with Section 140 capital B4. Those of you who have your Finance Bill handy with you, let's go to slide 2. Those of you who have handy Finance Bill, just straight away jump to the clause which deals with the amendments to provisions of Section 140B, subsection 4, which clarifies that the interest payable under 234B, which is the delay or deferment of advance tax, shall be computed on amount equal to assessed tax, as reduced by the amounts of advance tax or prepaid taxes which have been claimed in the earlier returns. So this helps in clarifying the position by omitting a particular phrase, and the effective date is from 1st April 2022. This is a retrospective amendment. Why? Because the concept of updated return was also introduced by Finance Act 2022. So this is the only change which we have with regard to the concept of scheme of filing of updated taxes, updated return. So can we move to slide 2, please? If one can flip. Yeah, this is what I was talking about, the change. If you carefully look at the last but one bullet of this particular slide, you will figure out that the phrase which is italicized is what has been omitted, and this is the impact of the amendment proposed in the Finance Bill 2023. 3. Yeah, moving on to the next slide, please. Can we move to the next slide? Yeah. So one more stakeholder comes into the picture now, so to speak, as if we had a shortage of number of experts which should be around while the uh, audit process is continuing. So what has happened now is that a cost accountant uh, can be requisitioned for the purposes of inventory valuation. Now, the lawmakers do have a belief that inventory valuation is something which over a period of time has become complex, and it's not easy for the assessing officer to purely rely on his skills and judgment. And at the same time, we all understand that under various compliance provisions under corporate law, you have a mandatory cost audit in place for certain section of manufacturing and other companies. So just to have an ability of an expert who could be requisitioned, there is an amendment proposed in section 142 to capital A, where a AO could direct the assessee to submit a valuation report which is procured from a cost accountant for the purposes of inventory valuation. So the way you have experts which are impaneled, be it impaneled experts of chartered accountants to conduct special audit, on similar lines you will have an impaneled panel of cost accountants whose services could be requisitioned by the assessing officer to furnish a report on the inventory valuation. And the effective date of this particular provision, which has been introduced while amending section 142 of the Income Tax Act, is with effect from 1st April 2023. Next slide, please. Yeah. So this is pretty much the amendment which deals with introduction of the services of a nominated cost accountant. Yeah, next slide, please. The remuneration, etc., will be determined by the chief commissioner or the principal commissioner in accordance with the prescribed guidelines. As I said, there's a panel of cost accountant which would be maintained, and accordingly, the modalities with regard to fees, housekeeping, etc., would be kept in mind. Now, let's come to the next provision, which is an amendment in the reassessment provision, which would be of somewhat interest to the audience, because reassessment provisions have pretty much taken the center stage in the last couple of years, ever since the new scheme of reassessment was introduced. And still now we find courts being very busy with various litigations and pursuits on account of reassessment being contested at various forums, and the matter has traveled already to Supreme Court on numerous or couple of occasions with this famous decision of Ashish Agarwal and Anshul Jain, and it's likely to knock the doors of the Supreme Court one more time on various aspects. So coming to the provisions pertaining to the limitation, there have been some amendments in section 148, 149, and let's look at those amendments. Next slide, please. First and foremost, the return period which is required to be filed once a notice is issued under 148 has to be furnished within a period of 3 months, so to speak. Now, if 3 months are extended, then you have to furnish it within the extended time. Now, assuming the period is extended by the AO upon an application, and you do not end up filing the said tax return. So there could be two situations: either you file it within 3 months, or you are unable to file, you seek an extension and the extension is forthcoming, and even after the extended period, you do not file it, then if at all you file such return beyond the period of 3 months or the extended time as the case may be, that return shall be deemed to be a return not filed under 139. So in other words, it's not a return which would be considered and taken on record for the purposes of reassessment provision. So that's one hard stop timeline which has now been provided by virtue of amendment to section 148. Now, the next amendment is with regard to the time period, and we all understand the time period is encapsulated under section 149 of the Act. So let's look at the time period for issuance of notice, which is in 149 of the Act. And next slide, please. Now, what happens is that there could be instances where search, survey operations are initiated just in the nick of time before the end of the financial year. And because they are undertaken before the end of the financial year, the time period which will be reckoned for the purposes of limitation would be reckoned keeping in mind that particular financial year. So, due to paucity of time, although the revenue feels that it should get some more time, but it does not get time, or they have to do a hurried job because the year is coming to an end, and if they don't do it, then you have 31st March staring at you. Now, before I move further, let's bear in mind the new scheme of reassessment. The new scheme of reassessment which we have, insofar as matters which deals with search, section 148 capital A is given a go by, right? And insofar as survey provisions are concerned, section 148A compliance has to be done. However, in both the situations of search and survey, it would be deemed that there is an information which is already available. So the only difference between search and survey is the fact that in case of search, under the new scheme of reassessment, we all understand that the search provisions are also encapsulated or embraced now in the package of reassessment. Earlier, we had special assessment provisions dealing with search 153 capital A, B, C. And prior to that, those who've been doing income tax search related practice, we had chapter 14B, which was the special provisions again dealing with search, popularly known as block assessment. So what happened? Block assessment was there up until 2005, which paved way for special assessment provisions for search 153 capital A, B, C. Once the new reassessment regime was overhauled and we had the new reassessment regime effective 21, the 153A, B, C were given a go by. Now, even the search reassessment will be conducted under the reassessment provisions. You don't have to look at any other separate provisions for assessment for search. The search related provisions in terms of search operations, etc. under 132, they stay as it is. So once a substantive action under 132 has happened, instead of moving to 153A, B, C, you will come to reassessment provision. However, because a search has already been conducted, it will be deemed that there is some information which is available. So 140, that provision is given a go by. And also 148A, the GK and drive shaft provision, which has now been encapsulated in the reassessment provision, where the assessing officer has to furnish a reason, replies are sought, and then he has to pass an order under 148 capital A D. That also has been given a go by in search, but not in survey. So survey also, there is a first level of go by given insofar as deemed information, but 148 capital A hurdle has still to be negotiated in a survey matter by the tax department, right? So to that extent, there is a difference between search and survey, right? Now moving forward, the whole reassessment has to be carried out, and there are certain survey and search actions which do happen in the nick of time, so to speak. Now, assuming that there are search or surveys action which are made post 15th of March of a financial year, then the time available is only 15 days. So that leeway is being granted, and we'll see the leeway when we look at the next slide, please. Yes. Now, what the finance bill does, if you look at the second bullet, that after the second proviso in section 149, two provisos are proposed to be inserted, and I have underlined this, which is not a good, good postulation when you do PowerPoint presentations. You are not supposed to underline, but just to give an emphasis, any post-search requisition where 148 expires on 31st March of such financial year, in that particular case, 15 days shall be excluded, and it shall be deemed to have been issued on 31st March of such financial year, by virtue of which you get another year, so to speak. Right? Similarly, where the information referred in explanation 1 emanates from a survey action under 133 capital A or 131, which is the third bullet, again 15 days shall be excluded, where the survey etc. takes place after 15 days. So the limitation provision in the sixth proviso again has been substituted, that it should not coming to that, the limitation provision should not exceed 7 days to the AO for passing the order. Now all these amendments are with effect from 1st of April 2023. The genesis or the rationale of this amendment is to give little more time to the revenue to be able to conclude their fact finding exercise, and by virtue of this they get 1 more year. Now let's move on to the next slide, please. Now 151 also has been a bane of contention insofar as whether a proper and a requisite approval has been obtained from the which we call it as sanction for the purposes of initiating reassessment provision, and we have a lot of judgments, NC cable, etc., where you found courts frowning situations where either proper sanction or not a reasoned sanction was not on record, and therefore reassessment provisions, initiations were quashed on account of lack or proper or reasoned sanction. Now, what 151 does is that on an administrative side, that the authority for the sanction would be the principal chief commissioner, and where there is no principal chief commissioner, the chief commissioner should give approval within a period of 3 years. Now, to clarify the specified authority for cases where reopening was done after 3 years from the relevant assessment year, stating that the relevant authority under section 151 shall be the principal chief commissioner, principal director general, chief commissioner, or DG. So where you are looking at situations where reassessment cases are for a period of years which go beyond 3 years, then these are the specified authorities. So one needs to keep in mind that when you are looking at cases where reassessment is being done for a period beyond 3 years, then these are the designated authorities. We all are very well aware that under the new reassessment regime, you have a go back period up to 10 years, so to speak. So anything beyond 3 years, just consider whether the relevant authority, which is the sanctioning authority as specified under 151, has granted the approval or not. Next slide, please. The proviso to 151 has been proposed to be inserted so as to provide that while computing the period of 3 years, the period which has been excluded or extended as in accordance with 149 shall also be taken into consideration. This is pretty much a consequential or a harmonization amendment that when you compute your 3 years, the periods which are the limitation periods as included or excluded in 149 will also be taken into consideration. I mean, I'm sure if the participants and the delegates can appreciate that this particular proviso has been proposed only to harmonize the situation. Again, all these amendments are with effect from 1st of April 2023. Next slide, please. Okay, I do acknowledge and welcome a very dear, respected Pramod sir. I think he's joined and he is really one of our North Star when it comes to the tax jurisprudence. So I welcome Pramod sir. Now, moving forward, there is a slight alignment with regard to the provisions encapsulated under section 153 with regard to completion of assessment. Now remember, there's a difference between 149 and 153, which we are all aware. The elementary difference, 153 takes care of the completion of assessment, 149 deals with the timeline with regard to 149, which we've just dealt with. So don't get confused between 149, which is the limitation period, right? And 153 is the time limit for completion of assessment. Now, everybody felt even in the faceless regime, this 9 months period is a short period to complete the entire process of assessment. More so when you have significant time under 143 to proviso to issue the notice. So if you get a notice fairly towards the fag end, technically you get very little time, as little time sometimes as 6 months only for you to be able to hurriedly do the assessment. And now with faceless regime, there is a fair bit of back and forth. So the 9 months period seemed very short. That has now been, it is proposed to amend 153(1)(a) to push the time limit to 12 months from existing 9 from the end of the financial year in which the return is furnished. So all along in the last couple of years, we saw the limitation period from 24 months getting shrunk to 9 with every Finance Act chipping away the time period for completion of assessment. Now a 3-month breather has been given. So this is a very positive and a welcome relief, so to speak, to the tax practitioner and to the in-house tax community. Yeah, next slide, please. Similarly, next slide, could we move on to the next slide, please? Yeah, similarly, when you have search related operations, Finance Bill 2023 proposes to insert subsection 3 capital A, where they all get extended by 12 months in all categories of post search and post requisition assessment. Again, the period available shall be extended by 12 months. So again, there was felt that you have lesser time to accomplish the assessment or reassessment initiated pursuant to search matter. So that also gets extended by 12 months. So that's also that, of course, as a taxpayer, you don't want the revenue to get more time, but then fair to say, to be able to align situation and conduct proper scrutiny, this also has been introduced. Again, as I said, the heading of the slide is aligning the timeline provision. So all this is in the process of alignment. Now, coming to some other alignment of timelines we have alignments in revisionary proceedings under 163 and the alignment with regard to the time limit to pass orders for transfer pricing. Yeah, let's look at those. Yeah, next slide, please. So, Finance Bill 2023 proposes that 153 is amended to provide that provisions of subsection 3, 5, and 6 shall be applicable with regard to revisionary proceedings also, and 264 orders. And again, these amendments are with effect from 1st of April 2023. So, these amendments enable the Principal Chief Commissioner and the Chief Commissioner to pass an order of revision under these sections, because hitherto they did not refer to orders passed by such authorities. So situations where orders could be passed by such authorities is now what is now conceived. Again, the idea is to streamline and harmonize various provisions of the Act so that all are on the same page. Some provisions did empower a particular designated authority to do something, while the other provisions did not recognize those. I think you will hear them in extenso from respected Pramodji when he takes up the appeal provisions, because again the same thing was happening. Few enabling amendments have been proposed again to harmonize those.
Aseem, I'll suggest you deal with this at length. I'm going to be very brief.
Yeah.
So please.
No, I'm just saying that you do not speak on this. So I'm rather trying to suggest that I'm not going to speak on this. Yeah. Moving on. Next slide, please. Now, again, I leave the last word to Pramod sir on speaking on the appellate side of it. Suffice to say that fair bit of revenue is locked up in litigation, and now you have Joint Commissioner appeals. I will not use the word that these are small causes appeal, but you're creating a larger pool of the commissionerates, so to speak, to deal with situations. Of course, the orders which are passed by authorities superior to the rank of Joint Commissioner appeals will not be appealable before the Joint Commissioner appeals. Again, I'll leave it to the authority to speak on this. Next slide, please. Yes, again, these amendments are again with effect from 1st of April 2023. So pretty much the takeaway from this very quick rundown on the amendments proposed in Chapter 14 deal with the reassessment timeline under 149, giving 1 more year, 153, harmonizing the few or equalizing few situations where few authorities were not designated and few were designated. I think the highlight or the larger headline point is giving 1 more year to finish situations where just-in-time surveys or search were conducted post 15th of March, giving 3 more months to complete the assessment proceedings. So these are the larger takeaway. I think with this, I'm sure all of us are extremely eager to lend our ears to Pramod sir. Back to you, Ridhima.
Thank you so much, sir. That was a very insightful session indeed. Can I take few queries if you allow? Sir, I think you are on mute.
1 or 2 and rest I can reply offline. I'm sure everybody is keen. We should pay a premium to the time of Pramodji.
Aseem, I'm a retired man. I have all time in the world. Premium is on. Please carry.
Intellectually, I think you're still hyperactive.
No.
Okay, Ridhima, let's take 1 or 2 very quickly.
Okay. So, 1 second. Can the faceless prescribed authority issue 143(2) notice to all assessees, including central and international taxation cell?
No, why? A few of them are not still part of faceless. No? So, I mean, you can't say this statement carte blanche, yes, there are still an e-assessment situation going on. So there's a difference between faceless and e-assessment, and certainly the investigation department is still not covered with faceless. So the answer is a qualified yes or a qualified no. Next, yeah, 2 more questions. That's it. I can answer all questions, but it's just that I don't want
Definitely.
people to wait.
Correct. So next is, can additions under section 153A be made in the absence of incriminating materials?
For that sub judice, the matter is going on before Supreme Court as we speak.
Oh, okay,
Justice
great.
Shah's bench is hearing the matter, and I thought some extensive arguments happened unless the judgment is reserved and the arguments are concluded.
Noted, noted. So another one I think is related to appeals. I'll take it forward with Pramod sir.
Yeah.
Thank you so much, sir. It
I
was
must
a
thank
very
you for the special thing of being able to give FaceTime with Pramod ji.
That's so sweet, sir. Thank you so much, sir. Thanks a lot.